Okay, good morning, everybody. Still waiting on a number of people to join us, but why don't we go ahead and get started so we can be timely and plow through the materials and not keep you folks beyond the allotted duration of the program. We've entitled our program this morning, New Year, New and Not So New Employment Law Challenges, and hopefully by the time we're done with the session, you'll understand why we utilize that particular title. We can go to the next slide. We'll lay out the agenda for today. So we have four different segments of today's presentation. They'll run probably 30 to 45 minutes or so each. Please feel free to pose questions in the chat, either during in the particular presentation or afterwards, whatever you like. We'll try and get to as many questions as possible. And if we don't get to your question for whatever reason, you want to follow up with us, our email addresses will be at the end of the slide presentation, and is otherwise available in any number of ways, including on our website. So my name is Larry Pikus. I'm the chair of the Labor and Employment Practice Group at Wiggin and Dana. We have several panelists who will be speaking today. I'm going to cover the first segment of the program entitled OSHA's ETS met its demise, now what? Which will focus on where things stand in terms of vaccination requirements, compensation issues as it relates to vaccinations, and so on. Then we're going to talk about a topic that's doesn't really get enough coverage often, which is state legislation. The federal government, as folks are probably well aware, tends to be in a bit of gridlock these days and preoccupied with a whole host of issues, and therefore basic labor and employment related legislation is often focused more on the state level and the local level than it is on the national level. So we're going to talk about some new legislation in a variety of states that may cover your operations and or be the types of legislation that might venture across the country to other jurisdictions by way of a model. We're going to talk about the National Labor Relations Board, what's going on over there in our third segment, primarily because with the new NLRB under a Democratic administration, we're starting to see a reversal of what was done under the Republican administration and looking more like the previous administration under President Obama, where there was a very assertive and aggressive NLRB issuing decisions that apply well beyond the union sector into companies and industries that do not have unionization. So we want to focus on that because of the broad implications there. And then we're going to talk about immigration compliance in the current climate. So let's go to the next slide. And then the one after that, since we've seen this title. Okay, so I'm sure everybody read about and heard about the emergency temporary standard that was issued by OSHA after a lot of haggling and discussion and anticipation. It finally came out on November 6th of 2021. And as many of you probably know, it applied only to employers with 100 or more employees. There was some uncertainty as to how you count those employees, whether there was guidance on the subject, but that was the threshold that OSHA decided on. And what the ETS required was that employers with at least 100 employees adopt a specific policy requiring their workers to be vaccinated, or alternatively submit to weekly testing while wearing face coverings in the workplace. As I'm sure everybody knows, that ETS was subjected to multiple legal challenges in several courts. Those actions and cases were consolidated on appeal at the Sixth Circuit Court of Appeals in Cincinnati, and the Sixth Circuit, in a fairly comprehensive decision, actually upheld the ETS as a proper exercise of administrative power by OSHA. And naturally, that decision was appealed up to the Supreme Court, and the Supreme Court had a very different view of the ETS and its enforceability. Essentially, what the Supreme Court says is that COVID is not a workplace hazard or a workplace danger per se. So OSHA overstepped its bounds by invoking the ETS and monitoring, regulating workplace requirements in response to COVID. They should basically stay in their lane, is what the Supreme Court said, and focus exclusively on workplace specific hazards, not general public health hazards that applied not only in the workplace but beyond and the country as a whole. So the ETS was halted by operation of the Supreme Court's decision. Next slide, please. And then OSHA withdrew it, which was pretty much the only course of action that they had at that juncture. Now, keep in mind, the ETS, as its name suggests, emergency temporary standard, was only going to be in effect for 6 months anyway. That was essentially buying OSHA time to adopt a permanent rule or permanent standard. And that's what OSHA initially announced that it was intending to do, was take the ETS as a model for a proposal of a permanent standard, but they really haven't done anything on that front yet. And they, hopefully with COVID winding down a little bit, I saw yesterday California, I believe it was, is sort of transitioning into the endemic as opposed to pandemic phase of the COVID situation. And we've seen that in other countries like the UK. And so you're starting to see it move into the next phase. My sense is that this will become less of a priority as COVID becomes hopefully less of a problem throughout the country, and OSHA will dedicate its attention elsewhere. Keep in mind there are state mandates, so do be cognizant of what's going on in your state or the state where you have operations. There's a patchwork of rules and regulations as it relates to vaccination requirements and the like in pockets of the country. So you want to make sure that you stay on top of those requirements in each individual state. Next slide, please. Okay, so what does this mean for vaccine mandates? And when the ETS was adopted back in November, and even beforehand, quite frankly, many employers were, as would be natural, compliant and implemented policies along the lines of what OSHA required. And as noted, some companies had done this even before the ETS as a matter of safety protocol to require employees to be vaccinated if they were interacting with other folks in the workplace. This doesn't change the legality of those policies. Employers are still free to adopt a vaccine mandate and require workers who interact with others, whether it's customers or other employees, to be vaccinated, or alternatively abide by testing and masking requirements. The EEOC has from day one, even before the ETS, taken the position that the Title VII and the ADA and other discrimination laws and state laws have sort of fallen in line too, as best we've seen, but that those laws don't prevent employers from imposing vaccine mandates for workers who physically enter the workplace. The caveat, of course, is that there must be exemptions available for folks who require reasonable accommodations, i.e. Cannot get vaccinated or vaccination is contraindicated because of some medical condition, or have a Title VII based religious objection to being vaccinated. To my understanding, there's very few medical conditions that would preclude vaccination or make it dangerous to be vaccinated. But you could certainly want to have in your policy that those accommodations will be considered and explored, and you can require documentation to back up the request for an accommodation, of course, medical documentation, and test the veracity of the suggestion that an accommodation is required. Religious accommodations, of course, are a little more complicated. All right, go to the next slide, please. Okay. It's very difficult to test an employee's subjective statement that getting vaccinated conflicts with their religious beliefs. Some employers, and arguably employers generally, would be well advised to basically accept that representation at face value. Some employers, though, have challenged claims that getting vaccinated is inconsistent with a particular religious belief by requiring employees to get some sort of a note or documentation from a religious authority within their religious sector, and oftentimes that kind of documentation is hard to come by because the religious framework for objections to vaccinations is a little obscure. But that's an option. But what we've seen in our experience is very, very few requests for accommodations based on religious beliefs, in order to avoid delving too deep into an individual's religious practices, in this particular area where there's a hefty amount of subjectivity and individualized thinking. Oftentimes employers will just grant the accommodation request without delving too deep into it. But you do have the right as an employer to explore that the religious basis of an objection, and to test the veracity of that objection, to determine whether it is in fact heartfelt and true, or just an excuse for someone who just doesn't want to get vaccinated. There's an undue hardship exception, which is also interesting, both from the ADA perspective and the Title VII perspective. Is it an undue burden on an employer or an undue hardship to have an unvaccinated employee in the workforce? There's a whole host of factors that might go into that assessment, such as how and what type of proximity does the employee work with others. So you want to look at sort of the nature of the work environment. I've not seen any cases that test an undue hardship defense to a request for accommodation, be it on religious or disability-based grounds. So we haven't seen those cases just yet, and they tend to be difficult cases, especially under the ADA, where the undue burden test is a little bit more demanding on employers than is the undue hardship test under Title VII, where basically anything above a modest cost or expense would be considered an undue hardship. But here, usually it's an issue of safety. You'll be taking an undue risk by allowing an unvaccinated employee into the workplace. Probably a difficult showing to make when regular testing and masking requirements may be adequate to protect folks against being infected, but the case law in this area just says you have to develop. Next slide, please. One interesting case out of Texas involved a group of United Airline employees who sought to enjoin the airline's policy requiring workers to be vaccinated or placed on unpaid leave if they had a medical or religious exemption. So the accommodation was not you get to work subject to testing or masking requirements, rather you just go on an unpaid leave. So the workers sought to enjoin the policy in the district court in Texas. And next slide, please. So the district court originally granted that injunction based on a finding that the employees had not established irreparable harm. And essentially what that means is that the court said, well, if you're out of work, you can recover money damages as a remedy for being displaced or being put on unpaid leave if you win your case. An injunction is a preliminary determination. It's not a final ruling on the merits. If down the road you win your case, you can get money, therefore there's not irreparable harm. That went up to the Fifth Circuit Court of Appeals, which has been the most receptive court to COVID-related challenges, workplace issues. And the Fifth Circuit reached a different conclusion, finding the workers had shown irreparable harm, notwithstanding the availability of monetary damages to compensate them for the lost wages should they prevail in the case. The court concluded that the employees were being forced to choose, quote, between pay and adhering to religious convictions, and that was a harm of an irreparable nature, according to the court. So they sent it back down to the district court. Next slide, please. Over a dissent of one of the appellate court judges who accused the majority of wanting to play CEO of a multinational corporation, essentially the court establishing the company's policy as opposed to the company. So the case is back down at the district court level, where the district court's going to have to consider the other elements of a preliminary injunction case, most specifically whether the plaintiffs in this case are likely to succeed on the merits. The district court didn't see any reason to address that issue initially because of the finding that there was no irreparable harm, meaning that an injunction would be unwarranted regardless of the merits of the case. Now the court has to look at the merits. And given prior Fifth Circuit decisions dealing with vaccination requirements and the like, in that jurisdiction, it may be very difficult for United to prevail, but we'll just have to see how that one plays out, and we'll monitor that case. Next slide, please. Okay, so let's look at vaccine mandates. As noted before, many employers adopted vaccine mandates either in accordance with the ETS or before the implementation of the ETS as a safety protocol. And according to at least one study, after the ETS was struck down, more than a third of companies that were polled indicated that they're going to proceed with vaccine mandates regardless of the ETS being invalidated by the Supreme Court. And it creates kind of an interesting conundrum in the current climate where there are significant labor shortages. What do they call it? The Great Resignation, employees who are leaving jobs, and many openings. Almost any certainly retail store that you go into these days, you see a "we're hiring" sign, among other industries where employers are having a hard time attracting workers. And there's this conundrum that employers are going to have to face when it comes to deciding whether to maintain vaccine mandates separate and apart from the legal requirements and the legal implications and the safety implications, of course, which are the paramount issues. But will it be more difficult or less difficult to attract employees if you have a vaccine mandate? I'm not sure that there are any studies to tell us the answer to that question, and it's obviously a highly individualized circumstance. But that's something that companies are going to have to grapple with. If we require vaccines, are we going to lose more employees, or are people going to be more comfortable coming to the workplace knowing that everybody had to be vaccinated, or regular testing and masking requirements so they feel safer, or if employees feel that their individual freedoms are being compromised if they have to get a vaccination that they may not want to get. Next slide, please. Okay, so let's look at some of the local, state and local requirements that have been implemented, or this is sort of ongoing at this point, although it's slowing down somewhat. So New York City, as of the end of last year, effective December 27th, 2021, required all employees who work in an environment where they interact with the public in the course of their employment to provide proof of vaccination. So it's a vaccine mandate in the 5 boroughs of New York City, subject to medical and religious exemptions. And employees who don't qualify for an exemption cannot avoid the mandate by opting for regular testing and masking. So in New York City, you either, if your employees are in a job that interacts with the public, then you either get, if you vaccinated, or you provide a documentation and justification for a medical or religious exemption. There's no other option in New York City. Next slide. And obviously there was a ramp-up period. So the employees had until, I believe it was early February, to get a first vaccine, and then I guess a couple of weeks after that for the second one. So there was time built into the process to get the vaccine. As you may have read, I think it was February 15th or 16th, New York City fired a bunch of workers who were not able to provide proof of vaccination by the deadline. And private employers would presumably be following suit, otherwise they wouldn't be in compliance with the city ordinance. So part of the obligation is for employers to confirm the vaccine status of the workers who were subject to this requirement, interacting with others, with the public or other employees. And then there's a series of ways to satisfy the requirement. The most simplest one being to just obtain a copy of the worker's proof of vaccination, which is of course documented, and you get your vaccine card. And that can be provided to the employer to establish that the vaccination protocols have been met. But the obligation is on the employer to confirm vaccinated status, and to maintain a record of the appropriate documentation. Next slide. Okay, what about independent contractors? If you have if the company, if your company employs or retains, should I say, consultants or contractors that are on site, otherwise interact with other workers or the public at large, what is the employer's obligation there? So in that event, you can have the contractor's employer confirm proof of vaccination, and you should maintain a log of the documenting that has been done, so that the certificate affirming compliance that's required to be posted can be accurate and complete. So what you want to do is you want to go to the employer of the individual contractor who's on your site and have them provide proof of vaccination or confirm proof of vaccination that they've checked and the contractor that they have on site at your facility is in fact vaccinated. Next slide, please. Okay, so let's look at some compensation issues. If you're requiring employees to, as many companies have, to either be vaccinated or regularly tested, if they're not vaccinated, who pays for the testing? Department of Health and Human Services issued guidance recently that provides for group health plans to pay for at-home COVID tests taken for diagnostic purposes. So that imposes the burden on the health plan. Some employers have more expensive health plans that may cover the test for other purposes, not diagnostic. But in the case that we're talking about, essentially for employment purposes, this is required for me to maintain my job if I'm not vaccinated. So you want to check your plans to see whether that kind of testing is covered, or some companies would just pay for it as an accommodation, or as a benefit to encourage compliance and avoid imposing costs on their employees that are necessary in order for them to maintain their employment. Next slide, please. Watch your state laws again. As I mentioned at the outset, we'll be covering other types of state laws in detail, but as it relates to COVID-19 tests in particular, a number of states led by California and Illinois have, as part of their wage laws, a specific requirement for employers to reimburse employees for work-related expenses. Many companies have those policies in any event, but that raises the question of whether a COVID test required to maintain continued employment that's not otherwise covered for insurance, is that a work-related expense? I haven't seen any cases just yet in any of those states that have mandatory reimbursement requirements. But of course, the simplest thing would be to just simply reimburse employees for those sort of expenses as it may be required either under your policy or under state law. Next slide, please. What about testing? Does the employer have to pay employees for time spent going to get tests if the employer has a policy requiring vaccination, or alternatively testing and masking as an alternative to being vaccinated? So if someone falls into that latter category and needs to go get tested periodically to confirm to the employer that they're not infected and can enter the workplace, is that time compensable? So under what's known generally under the FLSA as the continuous workday rule, if the testing is required to be done during work hours, then that's part of the continuous workday, and employees are entitled to be compensated for that time as though it was work time. And the Wage and Hour Division of the DOL has indicated that when testing is required by the employer to be done outside of normal working hours, but is necessary for the employee to maintain employment, that time is likely compensable as well. I tend to disagree with that assessment under the traditional test of whether a particular activity is integral and indispensable to the employee's core job duties. But that's an open question as well. Again, many employers will simply pay for the time as a courtesy, but it's an open question as to whether that time, if the testing is done outside work hours, normal work hours, whether that time is compensable under the Fair Labor Standards Act. Again, keep in mind state laws that may have more specific requirements. Next slide, please. Time spent completing required health screenings during work hours is compensable under the FLSA. Again, that's part of the continuous workday rule. The DOL has yet to address whether time spent being vaccinated under a mandatory vaccination policy is compensable time. Again, my view of that is that it would not be, but it's a very open question. There's certainly an argument that if the employer requires vaccination in order to maintain active employment, then it's sort of inherently become an integral and indispensable part of the job. That to me seems a little inconsistent with the Supreme Court's case law on what constitutes integral and indispensable functions. And I suspect these issues will play out in the courts at some point. We just haven't seen any definitive guidance from the DOL or a particular case or case law just yet. Next slide, please. Just a brief comment on telework. If you're requiring employees to continue working remotely and they have to purchase equipment to do that, of course, many employers will provide some sort of a stipend for employees to purchase equipment, or will provide the equipment such as a laptop without any expense to the employee. But in the event the company, for whatever reason, imposes those costs on the employee, you got to be careful about a minimum wage violation. If the incurring the expense in a particular pay period brings the employee or non-exempt employees wage rate below the minimum wage. Probably an unusual occurrence, but something to keep in mind is as a somewhat obscure issue. So if someone happens to spend a significant amount of money on a laptop that the company didn't provide because they need the laptop to work from home, and if you offset the wages for that particular pay period by the cost of the laptop, that would bring the employee, a non-exempt employee, below the minimum wage. There's theoretically a minimum wage violation there that could create legal problems. Next slide. I thought that might be the last one. So I don't see any questions in the chat, obviously. Well, maybe there are. Let's just see. Okay, I don't see any questions in the chat. If you think of something that's pertinent to the presentation on this particular subject, please feel free to raise questions in the chat as we go along, or send me an email afterwards, and I'll be happy to answer it. So wave of state legislation. Who's up next? I already forgot.
Larry, I'm going to start things off, and I'll be sharing this portion of the presentation this morning with my colleague, Nicole Dwyer. But first we'll say that when we conceived of this topic for today, sort of the idea was that in light of log jams in terms of progress on federal legislation, we wanted to focus on the ways that state legislators had stepped into the breach. And of course, since doing that, there was a significant federal development. So we wanted to start with that first. So next slide, please. So that significant development is the passage in Congress of the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. I understand that this has gone to President Biden's desk for signature. It hasn't been signed yet, but it would be effective upon signature. And he has indicated his support. The act guarantees employees the right to bring sexual harassment and assault claims to court, and prohibits employers from unilaterally enforcing arbitration agreements for claims involving those types of issues, sexual harassment and assault. It also allows employees to bring their claims either individually on or a class-wide basis. Next slide, please. So this is not going to be retroactive. It will apply to all claims that arise after the dates it's enacted. So that's a moving target right now. But again, that's going to be effective on the president's signature. So the action item here for you all is to be prepared to review and revise arbitration agreements if you are using them. This is particularly important because in some states, courts will invalidate the entire agreement based on one unenforceable clause. So you'd want to, rather than assume that a court would not enforce just one particular provision, take a look at the entire agreement and revise for compliance with the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. This is basically one of the latest iterations of a whole wave of legislation prompted by Me Too. for a couple years now, there have been concerns about sort of the confidentiality of settlements of issues involving sexual harassment and what is viewed as a restriction on employees' rights to bring claims in that area. So this is basically the next chapter in those issues. And we've already seen some states act on this as well, but this is federal law that will affect everyone. Next slide, please. So notably, the act does not prohibit jury trial waivers. So in looking at your agreements, you might still consider whether it would make sense to ask employees to waive the right to a jury trial. As you may be familiar either from personal experience or otherwise, jury trials can be incredibly unpredictable. And we've also seen very high verdicts involving allegations of sexual harassment and assault. Juries can get very hung up on some of the issues that those types of claims present. So it may still make sense for you to consider a jury trial waiver to foreclose some of that unpredictability and expense that an employer can face if defending allegations of sexual harassment. Next slide, please. All right, I'm going to turn it over to Nicole to talk about activities in Connecticut in terms of cannabis and also what we're seeing in New York and New Jersey.
I'll turn into the state law portion of this that we promised you all. We have cannabis legislation. So as you know, lots of states are legalizing the recreational use of cannabis products. And with that comes questions for employers about what implications that has for their drug testing policies and their use policies. So in Connecticut, we had Governor Lamont sign a bill allowing for recreational use of marijuana last summer. It allows for the possession of up to 1.5 ounces of marijuana and 5 ounces in a secured home or vehicle. So the retail sales for that begin this summer, and that's also when the employment-related provisions of that act go into effect. So those will go into effect July 1st of 2022. That being said, we should be considering what policies should be implemented in advance of that date. So the statute expressly states that an employer is not required to allow an employee to perform job duties while under the influence of cannabis. So much like alcohol, you don't have to allow your employees to come to work impaired, and there's nothing in the act that would require that. Next slide. In addition to that portion, which may seem more obvious, you can also continue to prohibit out of work use of cannabis, but that portion is much more highly regulated. So you have to implement a policy that prohibits the possession, use, or consumption of cannabis by an employee. And that policy needs to be both in writing and available to employees before the enactment of the policy. So for current employees, that would mean distributing it before the policy goes into effect. And then for employees who are hired after you've rolled the policy out, that would mean providing it to them in advance of the actual commencement of employment. So when you provide the conditional offer of employment, that would be something that you would provide to them at that time as well. Next slide. If an employer does not have a written policy in place that was provided to employees, the employer is not permitted to discharge or take any kind of adverse action against an employee because of the employee's use of cannabis products outside the workplace. That's where the importance of this policy comes in. You need to have it in writing that you do retain the right to take adverse action based on outside of work cannabis use. In addition, employers are not able to discharge or take adverse action against employees or applicants based on cannabis use that predates employment, unless the failure to do so would put the employer in violation of federal contract or cause it to lose federal funding. And that's generally an exemption that we're seeing in cannabis legislation, and particularly employment regulations, that allows for actions to be taken if it would place the employer in violation of their federal obligations. Next slide. Certain employers are exempted from the requirements of the statute. So the industries that are sort of exempted at large are healthcare, utilities, educational services, and some other safety sensitive industries. In addition to the employers who are exempted, in total, we also have exempted positions, which would include first responders, positions that require a CDL, positions funded by federal grants, and those that require supervision or care of children, patients, or vulnerable persons. So again, there's a focus on these safety sensitive positions and a recognition that those are exempt from the statute. Next slide, please.
Nicole, I'll just jump in before you pivot to New York. The employment related provisions in the Connecticut statute they're confusing. There's some ambiguity in there. The legislation was subject to a lot of 11th hour amendments. The legislator was really scrambling last summer to get it passed. And it seems to me, at least in the course of getting together a version of the statute that they could build consensus around to get it passed, some of these employment related provisions may not have been read together. Also, since it was passed, and Nikki will talk about some examples from New York and New Jersey, we've seen other states be more protective of employees. So in Connecticut, it's basically enough to put employees on notice of what the consequences would be of a positive test. But since this legislation was passed, we've seen other states, again, be more protective. So that's all to say, stay tuned. It would not surprise me if we saw in the future amendments to this in the state of Connecticut to align with the statutes that Nikki's going to talk about. There's a question, would a position requiring OSHA certification in Connecticut be exempt from the requirement based on being safety sensitive? So that depends on what the OSHA certification requires. If there's an explicit federal requirement for the particular position, but I think being trained on like OSHA compliance or something like that is not going to be enough to require that the person be exempt from this position. Under the Connecticut drug testing statute, all of which remains in place, employees need to be classified in a high risk or safety sensitive position to be subject to random testing, which may be part of the assessment here for safety sensitive position. So I'll turn it back to Nikki in the next slide.
So as Caroline mentioned, some other states are being more restrictive in terms of their cannabis legislation and how it impacts employment decisions. New York is one of those states. So New York Labor Law 201D prohibits employers from regulating employees' use of cannabis outside the workplace or taking adverse action against employees for such use, unless they're required to take action by law, which would include some of those federal contract positions and other federal funding positions, or the employee manifests specific articulable symptoms of cannabis impairment, and those symptoms inhibit the employee's performance or interfere with the employer's obligation to provide a safe workplace. So under New York law, it's actually not enough that they manifest symptoms of cannabis impairment. Those symptoms have to actively impair or inhibit performance or the employer's ability to provide a safe workplace. So it's quite protective. Next slide, please. New Jersey is more in line with New York. New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act, in addition to being a tongue twister, was signed into law on February 22nd of 2021. So this one came into effect last year. And the act prohibits employers from taking adverse action against an individual based solely on recreational marijuana use outside of the workplace. They are, again, allowed to continue to maintain drug-free workplace policies that prohibit use, possession, or influence of marijuana during work hours, though. It's just the outside of work use that cannot be regulated. Next slide, please. Employers may continue under New Jersey law to conduct their pre-employment drug screenings, but they can't refuse to hire an applicant or take adverse action against the applicant based solely on a positive test for cannabis products. So you can continue your drug testing, but you would not be able to screen applicants out based on a positive test for marijuana. There's also sort of an interesting twist to New Jersey law, which requires employers who are testing for workplace impairment to expand their drug testing procedures to include a physical evaluation, essentially to confirm that the person is actually impaired at work. And that physical evaluation has to be conducted by a certified workplace impairment recognition expert. Of course, we don't have guidance yet on what exactly it takes to become a certified workplace impairment recognition expert. And so that requirement is not going to be operative until the Cannabis Regulatory Commission actually adopts rules and regulations that set the standards for certification. And that commission has expressly stated that the provision will not, as of now, physical evaluations are not required until they provide more guidance on what exactly that's going to mean for employers. Next slide, please. All right, I will turn it back over to Caroline for family leave.
Great. And before I do that, I'll just address one other quick point on Connecticut is that all the requirements regarding employees who have medical marijuana cards remains in place. So even if you establish the policy we discussed for compliance with Connecticut, you'd still, that a positive test might be a disqualifier, you would still need to engage in a dialogue with your employees who have those medical marijuana cards. Because again, we've seen over the years legislation, case law on that topic that pretty clear that unless there's evidence of use on the job, that medical marijuana use needs to be accommodated outside of work. So in these last couple of seminars that we've done, we've spent a good deal of time gearing up for what happened on January 1 of this year, which was the effective date for both the availability of paid family leave benefits and the effective date of some significant changes to the Connecticut Family and Medical Leave Act. And if you were able to join us in October, we were lucky enough to have a representative from the Paid Leave Authority join us to talk us through some of these specific changes. So we don't want to spend too much time on this today. We just wanted to kind of talk about things we've seen since the beginning of the year. Overall, I'd say our perspective is the rollout's gone maybe a little bit smoother than one might have even thought, but there are some recurring issues that are popping up. First, though, we thought this is a helpful reminder chart of what the respective responsibilities are with regard to paid family leave benefits. I think some employers are still kind of learning that there's not much for them to do with regard to paid leave benefits. It's really an employee-oriented process with the employee engaging with the paid leave authority and the employer's responsibility essentially being to respond to the authority's request for employment verification and validation of absences, use of other available paid time and things like that. So it really is an employee-driven process with the employee engaging directly with the paid leave authority. Next slide, please. So in addition to the availability of paid leave benefits, there were changes that went into effect on January 1 with regard to both the coverage of Connecticut's Paid Family Leave Act and eligibility. So in terms of employer coverage, the most significant change was reducing that 75 employee threshold all the way down to 1. So for those of you on the line that were under the 50 employee federal threshold, for the last 2 months, this has been new frontier for you in terms of needing to think about and comply with these leave benefit available job protected leave for the first time. So if you've not yet looked at those policies, or if you were already covered by the FMLA but haven't yet taken the time to make sure your policies comply with Connecticut's changes, please reach out. All of us have been working with employers to get policies updated or rolled out if FMLA is brand new to you based on your head count. There are also changes to the amount of leave. We've always focused on this as maybe one silver lining of what was otherwise kind of a burdensome change to the FMLA. Connecticut's FMLA used to be 16 weeks and 24 months. Which ran concurrent to the federal entitlement of 12 weeks and 12 months. And it could be kind of a struggle to run the clocks on both types of leave and figure out when an employee who had exhausted federal leave entitlement would still be entitled to additional time under Connecticut's formula of 16 weeks and 24 months. That's gone. So now under Connecticut law now aligns with federal law, 12 weeks and 12 months. The Connecticut Department of Labor released interpretive guidance on how to transition to those new provisions if there was an already approved Connecticut FMLA leave, because the natural question, of course, is, well, with this change from 16 weeks to 12 weeks, how does that affect employees who have a leave that crosses over between the calendar years? So per that guidance, if an employee started a CT FMLA leave prior to January 2022, the duration of the leave is still going to be capped at 12 weeks in the applicable 12-month period as of January 1, even if you were approved for and commenced 16 weeks of leave in 2022, even if you were approved for and commenced 16 weeks of leave in 2021. That guidance goes through the various calculation methods that you can use under the FMLA and includes some helpful examples. So you could use a calendar year method, a rolling method, look back method. The guidance marches through basically how this would work using each of those methods. Not going to tell you it answers all questions on this topic. I've already encountered some specific factual issues that are not addressed by this guidance, but it is a good starting point if you are navigating somebody who under the 12-week period would be coming up on a return to work based on 12 weeks of eligibility for a leave that started in 2021. Next slide, please. I see a comment that the Paid Leave Authority sent out an email yesterday that they're increasing their response time from 5 days after all documents are returned to 10 to 15 days response time. So that's interesting. I'm glad at least they've communicated their response time. To me, that tells me maybe they're a bit unprepared for the level of demand and interest in paid leave benefits, but we'll see. It could also just be that they're working through that initial transition. So we spoke a bit about the changes in terms of employer coverage and employee eligibility. This slide is just kind of the neatest way we can compare and contrast what those updates have been. Next slide, please. So this is, in addition to navigating changes of leave that carry over from 2021 to 2022, coordination of paid benefits with other PTO is the area where we've seen kind of the most challenges and the most questions from employers. So under this statute, employers are permitted to require an employee to substitute otherwise available paid time. Employees' total compensation during leave cannot exceed the employee's regular rate of pay, so they're not going to get over 100%. The Act does require that employees be permitted to retain at least 2 weeks of any such paid time off. Next slide, please. So we have to talk specifically about short-term leave, short-term disability, because the interaction of those benefits with the availability of state benefits has been, I think, the biggest source of questions. So this information was presented in October from the representative from the Paid Leave Authority who was able to join us. So basically all these if-thens for each scenario about an employee receiving employer provided PTO. So obviously if an employee doesn't have any employer provided PTO, the employee is eligible for the full amount. If they receive employer provided PTO that's equal to their regular rate of pay for the full period of leave, they are not eligible for benefits. And then the final two bullets are sort of the in-between position of either they have a full amount of PTO or they have no PTO. In between those two options, if the employee receives employer provided PTO that is equal to regular pay for a portion, then they're eligible for the full amount of benefits, but not until after they've exhausted that employer provided PTO, subject to retaining 2 weeks if they wish. If the employee receives employer provided PTO that is less than regular pay, the employee is eligible for leave benefits, but the benefit amount is reduced so that the combined total is not over 100%. And this is the option where we see some of those questions about short-term disability policies. Next slide, please. I'll turn it back to Nikki. I'll monitor the chat if there's any specific questions about headaches or issues that you've seen thus far in administering or having employees request these new leave benefits. Just let us know and we can circle back.
So before I jump into the New York City law, I'll mention that the EEOC has announced that it's going to be focusing on artificial intelligence tools and whether or not those promote discrimination. There's a concern that they could become a high-tech pathway for discrimination. So sort of in response to that initiative by the EEOC, New York City's taken it upon themselves to initiate their own measures. So beginning January 1st of 2023, so next year, New York City will require employers that use automated employment decision tools to make employment decisions to have those tools audited. They'll have to be audited by an independent evaluator to assess any disparate impact that they might have on persons who belong to protected classes. They'll also be required, once that audit has been completed, to post a summary of the results on the website before they actually use the tool in the course of making employment decisions. This law also has implications for those employers who work with recruiters or other third-party vendors to use these tools. So they'll have to ensure that anyone who they're contracting with to make employment decisions are also in compliance. Next slide, please.
Nikki, there's a couple questions in the chat about paid leave that I just want to go back to before you proceed with the pay transparency. So one is a question, does short-term disability pay before the Connecticut paid leave in Connecticut? We asked, we really pushed on that when the representative from the Paid Leave Authority joined us in October. That was a big source of question and concern. And the answer was very clear that it unfortunately depends on your policy, that your policy will dictate whether your short-term disability policy will dictate whether it is a primary benefit or a secondary benefit. So far, I've seen most employers learning from their carriers that it is a secondary benefit, so that the state leave benefit is the primary source and the short-term disability policy then will supplement whatever the employee is eligible for under the state leave benefits. But again, that is specific to your policy. That's just kind of the more typical outcome that I'm seeing from employers who've made that inquiry. There's also questions about that requirement that employees be permitted to retain 2 weeks of time. So first, is that only for continuous leave? And it is not. That is not specific to continuous leave as opposed to intermittent leave. All employees are permitted the option of keeping 2 weeks of accrued time. And the other one is, can the employee use the full 2 weeks at full pay or spread it out by taking a Connecticut paid leave and supplement that with available employer sponsored leave? So I think that question is asking, does the employee get to just go ahead and use their full time, or do they start at 100% pay, or do they start right away with collecting paid leave benefits and then use their accrued bank to top themselves up? So far, we understand that that's specific to your policy. So if your policy is requiring employees to concurrently use available accrued time, rather than exhaust it all first, you might have that second outcome where the employee first applies for and receives paid leave benefits and then can supplement what they're getting from the Paid Leave Authority, which is not 100% wage replacement, supplement that with available paid leave. And let's see, there's a specific question about an employee who has been out on a leave of absence, which started in September of 2021. She is now on LTD. Could she apply for Connecticut paid leave? She will be out indefinitely. So yeah, anybody can apply. It's the state that will make the determination about eligibility. If she has already exhausted benefit job protected leave, that might be a consideration from the Paid Leave Authority. Not quite sure how they're reconciling those two things yet for leaves that started in 2021. This is another question. They're coming in hot on the paid leave questions. So for Connecticut paid leave, the biggest issue is employees don't know what to do. We give the instructions, but they are so used to doing leave administration for them. I compare to unemployment for them. Also, the length of time processing has been an issue. Definitely heard that feedback as well about the processing and not really being familiar with the requirement that they are driving the process here. I've so far seen that the Paid Leave Authority website is fairly intuitive. So hopefully they're not experiencing too many roadblocks once they do get the message that it's on them to get the claim initiated online. Okay, so for higher paid employees, employee makes well over the CTPFL amount, actually would be able to collect the STD maximum of $600 a week and still not reach 100% of their normal pay. Can we let them collect it? So I don't know if that let them collect it refers to collecting short-term disability in addition to Connecticut paid family leave. But in that scenario, assuming your policy didn't say something different, under the statute, the employee would be able to collect both of those. CT Paid Leave Authority has paid one of our employees their full pay, in addition to that employee receiving full pay from us as the employer, due to her having both short-term disability benefits and large amounts of PTO available, which we confirmed on the employer verification form. She is making a huge profit being on medical leave. Do you know if they'll be reviewing? So they are supposed to be reviewing those claims. So I'd suggest following up on that one in particular. Because the purpose of the employer verification process is so that they know what other forms of payment the employee is getting. Our STD policy is secondary, but for one employee where STD continued paying until 2/6/22, the CT Paid Leave Authority paid the balance of pay until STD stopped paying 40%. Okay. That sounds right. I think I caught up on questions there, but if there's others, maybe we can take them up again at the end, and I'll let Nikki go ahead and talk through these pay transparency provisions. Thank you.
So another trend we're seeing is these pay transparency laws. We have states and localities increasingly passing them. So in Connecticut, last October, the law went into effect that requires wage range disclosures in job postings. Also beginning in May 15th, 2021, employers in New York City are required to include salary ranges in job postings. And beginning in 2023, employers in Rhode Island will be required to do the same. These laws do raise a couple of questions, including how are the ranges calculated for jobs that include commission-based payments or other kinds of incentive payments. Generally, the guidance is that you have to post the wage ranges that you believe in good faith could be the high and the low. So that's sort of how that's been answered at this point. Next slide, please. And I'll turn it to Caroline for the non-compete portion.
Thanks, Nikki. So this is an area where states have been fairly active. There was also some chatter at the federal level of whether this is something that Congress would take up. Not seen any concrete steps on that so far. So we're dealing with state by state action. For background, in many states, subject to some very narrow statutory restrictions, restrictions on non-competes are basically subject to judicially created concepts of reasonableness. So reasonable geographic restrictions, reasonable time restrictions, the reasonableness of scope in terms of how competition is defined and whether that exceeds what is necessary to protect an employer's legitimate business interests. But we are seeing this greater trend towards statutory specifics on that rather than this body of law that's existed and developed in each state. So for example, in Illinois, effective January 1, 2022, non-competes are prohibited for employees making less than $75,000 and non-solicits are prohibited for employees making less than $45,000. This is sort of a trend, the idea that non-competes for lower wage workers are really both unnecessary and unfair from the legislature's perspective. Oregon also had restrictions for January 1, 2022 that are new. They're restricted to just 1 year for employees below a particular salary threshold, or the employer is required to pay garden leave. Garden leave is a form of income replacement when the employee is restricted from competing but no longer working for you. Nevada, as of last fall in October, non-competes for hourly employees are unenforceable. So that's kind of another way to tackle that idea of lower earners, although of course you could have an hourly employee who is above some of these salary thresholds that we've seen in other states. Washington, D.C. is considered the most restrictive new law in the country, and it broadly restricts any non-compete signed after the law goes into effect on April 1st, 2022. Next slide, please. So in addition to those that have already gone into effect, there's some pending legislation, including 10 separate bills floating around in Connecticut. I'm not sure, how much progress any one of those will make, but of those 10 things that are percolating, some target physicians and home health aides. There's already a statute on the books that particularly addresses non-competes for physicians. This would modify that. Others have looked to mirror Massachusetts law. Massachusetts passed pretty comprehensive legislation regarding non-competes that went into effect in 2018. It has lots of particulars to it, including notice provisions, requirements for garden leave, specified review period for an employee to have access to the non-compete before they sign it, before it goes into effect. In New York, there are 3 separate bills that have been proposed. One restricting non-competes essentially for COVID-related reasons, one banning non-competes for low-wage employees, and one banning virtually all restrictive covenants and imposing up to $10,000 in liquidated damages per violation. And then at the outset, I mentioned the idea that there's kind of proposed action floating around at the federal level. President Biden's July 9th, 2021 executive order promoting competition in the American economy is an indication of the administration's hostility toward restrictive covenants. So there are now 2 bipartisan bills, each championed by Senator Rubio, popping around Congress. One is an outright ban and one is a ban for hourly employees.
Hey, Caroline, you had one question about the Illinois law.
Mm-hmm. I think it's full salary. Josh or Nikki, I don't know if you know if that's addressed specifically, but I think it's just $75,000 without specification for base salary versus commissions.
I think that's right. I can take a look at that and we can answer after in the Q&A at the end.
Great. Thanks, Josh.
Sure.
Next slide, please.
Okay, thank you, Caroline and Nikki. We seem to be on a pretty good pace here, staying within the operative time limits that we set for ourselves. We usually don't do that. So now we're going to talk about what's going on at the National Labor Relations Board. Keep your ears open even if you do not have a unionized workforce, because that will be the focal point of this part of the presentation. But the developments at the board that impact all employers, whether unionized or not, having to do with work rules and a whole host of other issues. And Josh, are you starting on this? Or is Caroline?
I'm going to start really
get started.
Yeah.
I always get you two confused. You look so alike.
That's not nice to say to Caroline.
We do have the same one. Next slide, please. Just give a quick introduction. This is something we started talking about last year. The change in composition of the National Labor Relations Board was basically an indicator of things to come. There's a new general counsel that started putting out memos almost immediately last year, signaling which areas would be the subject of her division's focus during this administration, and it was scary. There are things on the chopping block, long-standing precedent that she's looking to revisit in a way that would be detrimental to employers. And since we last talked about this in our October seminar, some of those things have started coming to fruition. So we wanted to talk through some of those developments with you, as well as what we could expect on some of these areas. First, we'll just address briefly on the next slide, please. Some filing trends. So in the past 10 years, aggregate unfair labor practice charges and representation cases per year have dropped. So representation cases from 2012 to 2021, you see a fairly precipitous decline. Same with unfair labor practices. Now, this kind of correlates overall to a decreasing significance and prevalence of unions in our economy, but it also means unions are getting more creative and in some cases more aggressive to kind of retain that foothold and continue to unionize new groups of employees. Visible successes with Amazon and Starbucks may yield an uptick in all petitions. Beginning in 2020 with the pandemic, there was some speculation that the pandemic and the way that it impacted the workplace could also indicate an uptick in unionization. And we've not necessarily seen that translate into numbers just yet, but that could still be coming. Unions have been very visible in terms of sticking up for what they contend are their employees' preferences and choices with regard to COVID protocols. So if you think, for example, about teacher strikes in Chicago and things like that to do with how school districts were handling COVID and how they were or were not taking steps to protect their employees. So while that hasn't necessarily reflected it, we could still see an increased activity in representation petitions triggered by any one of these things: COVID-related safety protocols, increased visibility of successes in companies like Amazon and Starbucks. Josh, I will turn it back to you.
All right, thanks, Caroline. So next slide, please. We're going to start with talking about joint employment. And so what we're generally seeing here is a pendulum. And so when the board's controlled has a Republican majority, it swings toward employers. When it's controlled by Democrats, it starts to swing back towards employees. So with respect to joint employment, what are the broad strokes here? What's at stake here? A joint employment finding has significant implications under the National Labor Relations Act relative to collective bargaining, strike activity, and unfair labor practice liability. So if an employer is found to be a joint employer with a unionized employee, and the employees of one employer are unionized, the joint employer has to participate in collective bargaining with their fellow joint employer. A joint employer, if picketing is directed at a joint employer, that would otherwise be unlawful in secondary picketing, it suddenly becomes primary and lawful if they're found to be a joint employer. And they can be found jointly and severally liable for another employer's unfair labor practices if there's a joint employment finding. So under the current existing rule, a business has to possess and exercise substantial direct and immediate control over one or more essential terms and conditions of employment of another employer's employees. The rule defines a whole bunch of terms, including what are considered essential terms and conditions of employment and what does not constitute direct and immediate control. It also defines what constitutes substantial direct and immediate control and makes it really clear that control exercised on a sporadic, isolated, or minimal basis is not substantial. So prior to that rule, which was adopted by the Republican board, there was a case called Browning-Ferris that really expanded the definition, the joint employer standard, to include companies that had indirect control or the potential to control another business's workers. The Republican boards tried, were stymied at a number of levels with procedural issues to overrule that, and then finally moved to rulemaking. And so they issued that final rule in February of 2020. And now the Democratic majority board is looking to rescind that rule and either resume case-by-case adjudication or issue a new, broader rule. And the board's approach here is likely to revert to something that looks more like the use of indirect factors instead of just direct and immediate control. All right, next slide. Okay, moving to independent contracting. So what's at stake here? Generally, we're looking at whether or not employees are covered by the National Labor Relations Act. So if somebody is considered an employee, they're covered by the NLRA. If they're an independent contractor, they're not covered. So in 2014, the Democrat-controlled board issued a decision in FedEx Home Delivery that used common law agency factors to look at the classification for independent contracting, asking whether or not the individual is engaged in a distinct occupation or business, whether the work is typically performed at the direction of the employer without supervision, whether the individual supplies the work tools in the place of work, and whether the work is part of the employer's regular business. In 2019, a Republican-controlled board made the independent contractor classification much easier and was looked at a whole host of factors, but really focused on entrepreneurial activity. How much opportunity does that worker have to control their own work? The case that they decided was in Super Shuttle, which had to do with I think it was an airport shuttle service, and the board looked at whether or not the drivers like owned their own vans, could sort of set their own schedules, and looked and said they have the entrepreneurial opportunity to control their work. But the board's now revisiting this issue in a case called Atlantic Opera, and has asked for public briefing as to whether or not they should overrule Super Shuttle, return to the FedEx test, or do something completely different. So we'll have to see. Either way, the board is definitely interested in going to something less than that's less direct than Super Shuttle, and moves away from the entrepreneurial opportunity analysis, which is obviously very favorable to gig economy workers and less favorable to employers. So we'll see what happens there. I believe that briefing is due like next week. So that's to be continued. All right, next slide. An interesting footnote on the independent contractor piece is that an analysis this year of employee classification cases under Super Shuttle found that workers were classified as employees in 10 decisions, but only classified as independent contractors in 1 case. By comparison, under FedEx, there were 17 where they were found to be employees and 7 with independent contractors. So I think the board is thinking about whether or not they want to just revert to FedEx or think of something new, because the results are not necessarily better under FedEx for employees. All right, next slide. Okay, so this is going to be a broadly applicable, you don't need to have a union concern here. Arbitration agreements. You heard Caroline and Nikki speak earlier about the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. The NLRB General Counsel, Ms. Brusso, has weighed in pretty publicly and said the bill does not go far enough to protect employee rights to collective action in sexual harassment cases, and then also allows employers to continue to pick arbitrators that are favorable to the employer and to demand confidentiality in other arbitration cases. And she says that should not happen. And on a parallel track, the board, in a case called Ralph's Grocery Company, invited briefing, again, as they did with the Atlantic Opera case, invited briefing from the public to determine a new standard for confidentiality requirements in arbitration agreements. In this circumstance, the board's inquiry is largely directed at the impact that a confidentiality provision is going to have in an arbitration agreement is going to have on an employee's rights to discuss the terms and conditions of their employment. If there's sort of a broad confidentiality provisions, you can't talk about anything, that could be unlawful. The board has permitted arbitration provisions with confidentiality provisions if there's a savings clause in the agreement that's sufficient to inform employees that the agreement does not restrict their statutory rights under the Act. But as we'll see in the next slide as well, the board takes a view that even including the confidentiality provisions can have a somewhat coercive and preclusive effect. So a corollary to this is the confidentiality and severance agreements. There's a case that was just decided by an administrative law judge in which a hospital furloughed non-essential personnel in June of 2020 because of the pandemic, and offered each of the furloughed employees a severance agreement, and included confidentiality, non-disclosure, and a release of NLRA rights. The hospital did not bargain with the unions impacting some of these employees over the severance agreements, and furloughs and layoffs are mandatory subjects of bargaining. So the ALJ looked mostly at whether or not they had violated the Act by not bargaining, and said they did. And the board, in front of the ALJ, the board's lawyer argued that a 2020 ruling in a case called Baylor University, which allows severance agreements with confidentiality and non-disclosure provisions, should be overruled. And the concern again here is that a separation agreement has the potential to intimidate an employee to not speak out about the rights of their the terms and conditions of their employment. And the chairman in a related Chairman McFerrin in a related dissent said what matters are employee rights under the NLRA, and which extend to former workers, not just to current employees. So important always to draw a carve out into your severance agreements to ensure that employees are aware that they are not going to be denied access to the National Labor Relations Board by signing either an arbitration agreement or a severance agreement, to have that carve out. I think all caps and bold is pretty helpful in that regard. But this board is pretty hostile toward even a savings clause, and thinking that the severance agreement in the first place is going to intimidate an employee. So we'll need to stay tuned on that, and we'll update you as updates become available. All right, next slide. Okay, so the board is again inviting briefing on work rule issues. This again is broadly applicable to all employers, not just those with unions. In 2017, the board issued a decision in Boeing that established a new standard for analyzing employer work rules, and that was later refined. But generally, you've got three categories of work rules. Category 1 are rules that do not reasonably interfere with protected rights. Category 2 are rules that warrant individualized scrutiny, and category 3 are rules that are unlawful. In a now pending case, the board invited briefing again as to whether or not it should adopt a new legal standard as to whether work rules in policies, handbooks, and the like violate the act. And so that could be a return to a decision called Lutheran Heritage from 2004 that prohibits work rules that although they don't explicitly prohibit or restrict protected activity, they can be construed by employees, reasonably construed by employees, to prohibit the exercise of their rights under the NLRA. So again, we'll stay tuned and see. That briefing, I think, is due in early March. So that's something that will be forthcoming from the board there as well. All right, next slide. Student
Hey,
athletes.
Josh, it probably
Yeah.
just bears mentioning that
Oh, sure.
under the old Lutheran Heritage test, as interpreted by the board during the Obama administration, a whole host of pretty typical and customary work rules that you might have were struck down as being subject to reasonable construction by employees, that they would not be,
Right.
it would violate the rule by exercising Section 7 rights, meaning engaging in discussing terms and conditions of employment among one another, otherwise engaging in conduct that would be for the for mutual aid or protection of the employees. I know I had one work rule that was simply prohibited inappropriate conduct in the workplace, struck down, believe it or not, as being subject to a reasonable construction by employees, that it would somehow inhibit their ability to communicate with one another for mutual aid or protection. Never really understood that, but it's just an illustration of how broad Lutheran Heritage has been in the past interpreted under a union-friendly or employee-friendly board. So just to put some color on that, work rules like that, prohibiting inappropriate workplace conduct, were struck down, and many others that seem pretty basic and fundamental to any workplace were struck down. That's why we focus on this issue, especially as one that applies across the board. And a lot of these cases arose, including the one I had, outside the union setting. The employer had no union employees. So it is important for everybody on the line to keep an eye on this and stay on top of what's going on at the board with regard to work rules, and if need be, modify their work rules accordingly. And then you can change them right back if there's a Republican administration and a Republican board next time around.
Right. And I think in a lot of cases, Larry, too, I think that that what it means is you need to be more specific in what you're prohibiting, right? I mean, I think it can't just be work rules. We need to, there can't be any inappropriate behavior. If you mean you don't want roughhousing, then you can say that, right? You can spell those things out and be a lot more direct about what you're prohibiting and not prohibiting.
Absolutely.
Okay. I think we are onto student athletes. Yeah. So the general counsel announced recently in a memo that she wants to reclassify all student athletes at private universities as employees under the NLRA. She said that the mere reference by schools to student athletes as anything other than employees is a misclassification and a violation of the act. She's taking a pretty hardline stance on this. It's likely that she'll allege the misclassification as a chilling effect that misleads student athletes to believe that they're not entitled to the act's protection. And so she's inviting student athletes to come forward and file charges. And no student athletes came forward to file unfair labor practice charges, kind of unsurprisingly. A lot at stake for young people who are, have a big career in front of them as student athletes. But a college basketball player advocacy group filed 2 charges on behalf of student athletes in 2021 and 2022. There's no standing required for an individual for this organization under the act. They're pointing out that there may be a violation of the act to the board, and the board will investigate and then and proceed from there. So with the support of the general counsel, this charge seems destined to become a complaint in the future from the board that could possibly change the law and change the face of college sports.
Yeah, I mean, the status of student athletes is probably not directly pertinent to most folks on the call, but it's an interesting slide just to give you an illustration of how aggressive the new NLRB general counsel is being on issues that even ones that appear pretty well settled. I mean, there's a 7th Circuit Court of Appeals decision from a few years back in a wage and hour case rejecting the notion that student athletes are employees and doing so in a pretty strongly worded opinion. And general counsel just doesn't seem to really care about that, and is trying to make new law in a whole host of areas. So this is just a stark example of why it's important to stay on top of what's going on at the NLRB.
Right. All right, and I'm going to throw it back to Caroline to wrap it up.
Great. Thanks, guys. Next slide, please. So we just wanted to address what this could mean and what you all should have in mind as we keep monitoring what this pretty aggressive composition of the NLRB and General Counsel is going to look like. Best advice right now is to stay tuned. This is an area where you really need to invest the time and resources to continually review these relevant policies to ensure compliance. We may see very swift changes in policy. Forthcoming decisions may require revisions to policies, severance agreement templates, arbitration agreements beyond the changes we referenced at the start of the presentation. We also encourage training of managers on rights of non-unionized employees. There's been a persistent misunderstanding about what rights non-unionized employees have under the NLRA, starting with the basic idea that the NLRA doesn't impact non-unionized employees, and that's simply not true. All non-supervisory employees have Section 7 rights to discuss the terms and conditions of their employment with each other, for starters. And making sure you have managers that are savvy on that point can help make sure you're not engaging in conduct that's going to result in an unfair labor practice charge that would then put you in the crosshairs of the NLRB that is really seeking to make law in some of these areas. We also suggest that you be pretty risk conscious and tread lightly if you're faced with discipline and termination involving these types of hot button issues like employee speech about work-related topics, confidentiality, social media, or the civility rules that Josh and Larry talked about a few minutes ago. Those are all the types of cases that we expect we'll see several iterations of before the board in the coming months and years. If there's a union organizing campaign or you're bargaining, this is even more important. The NLRB, like we said, is seeking to make law, and the remedies that the General Counsel is considering are expansive and could have long-term impacts on the dynamic with the union, not to mention financial repercussions. So this General Counsel is seeking some pretty extraordinary remedies in this context. You really don't want to be faced with. I think that's it for us in the NLRB section. I'm going to turn it over to Najia and Ashley.
Good morning, everyone.
Oh, okay.
All right. So I am Najia Khalid, and I lead the Business Immigration and Compliance practice. Ashley and I are going to cover a few of your favorite things with immigration and employment compliance reminders as the pandemic rages on. The key issues for employers that we're going to cover on the next slide, please. Essentially start with some of the visa processing challenges that are going on worldwide. With this, it's always critical to manage expectations and understand the difference between business realities for employing individuals, starting new individuals, and having business meetings and travel abroad versus immigration realities, which essentially delay things quite a bit. The second area we're going to cover is travel restrictions. There's a lot to know before you go, be it domestic travel or international travel. Essentially, for employers and for educational institutions, the key concept here is to try and remind employees and students to advise you before they decide to change locations last minute. A lot of things can be impacted based on where they are and if they get stuck during their travel. And then the third area we're going to cover is limitations on remote work. With this, I think I'm going to date myself, but I feel like the pandemic has maybe really go back to where in the world is Carmen Sandiego days, trying to figure out where's Waldo or where's Carmen Sandiego. We're keeping track of way too many people in different cities and different counties. That impacts visa compliance if you have foreign workers on specific types of visas. And then even for US workers, if they're in different states and different countries, thinking they're working remotely, they can visit and not communicate with the employer. We're facing some impact after the fact based on tax and immigration compliance. So we will cover a little bit of information on that area. Next slide, please. All right, so some of the basic visa processing challenges that any employer needs to be aware of, whether or not you sponsor work authorization on behalf of employees, is essentially that getting into the US is challenging. The US Department of State, which controls all of the embassies and consulates abroad, it was never fully staffed. Even under the Trump administration, a lot of the appointments were not made. And then because of COVID, things were exacerbated with closures and short staffing. So there are a lot of posts abroad that don't have staff still that are processing certain types of immigration cases. Even for US citizens, although those services are a priority, it's hard to get emergency or urgent appointments if there's no one actually working in a consular location. For immigrant visas, which are individuals that are green card holders, family-based sponsorship, and a number of employer-based cases where individuals happen to be abroad, some of the consulates, they have like 1 day a month where they're processing these types of cases, if that. So it's really critical to think through who are you trying to work with, or who are your students and where are they going to be, because they might not be able to get into a consulate for something that they need to get into the US for maybe a year. In terms of temporary visa holders, a lot of the work visas that the typical clients we have work on, H-1Bs and that nature, they have different priorities based on the location. There are some consulates that will make exceptions for medical professionals, au pairs, some are prioritizing students and so forth. But overall, it's everybody needs to be expedited. Everybody is looking for an appointment, and everybody is trying to make a request for urgent attention. And because of just the backlogs, everybody's expedite request is now kind of falling to the bottom because there's just no capacity to address it. I'm not trying to paint the horrible glim picture. I really want everyone to understand that there are limited resources to request expedites. A lot of times business needs are not considered an emergency unless you're facing a lot of multi-million-dollar US economic loss, a severe loss to US workers. But essentially in the back of your mind, you need to keep conscious of the fact that it's crisis level backlogs with the US government agencies at most US consulates worldwide. Appointments are really limited. And for Indian nationals, I'll bring this up in particular, we have a lot of clients with IT professionals that are stuck in India still because we don't have appointments available until 2023. So for those individuals, we're developing remote work possibilities. And India, I bring up because if you have one remote worker in India, a US company can be found to have corporate presence in India. So there are tax and employment and immigration consequences for that. So this is kind of the backdrop of it's really important to have the information and have your advisors, be it your employment counsel, your immigration counsel, or your tax counsel. We all need to be aligned and understand where are your people. Next slide, please. All right, so there are also challenges with individuals that are staying in the US. The US Department of Homeland Security is the agency that manages everything for individuals applying for work authorization and such on US soil. And what we're finding a lot of employers facing is that, again, crisis level processing times of over 1 year in many cases mean that sometimes you can apply for work authorization renewal. The maximum time in advance is 6 months. So we used to plan about 7 to 8 months out, have the case ready, submit it 6 months out, but essentially the government is taking over a year to process. So there are employment authorization gaps occurring more frequently. Some of the relief proposed by Congress and working through with the agencies is to automatically extend work authorization. But I wanted to bring it to your attention that this impacts I-9 re-verification. It also impacts employment benefits and leave, and your policy in terms of how long are you going to allow an employee to be on unpaid leave or be temporarily terminated and hold their job if, for example, an employment authorization document, if they can apply 6 months in advance, but it's taking 13 plus months for them to receive it, are you going to hold that job for 7 months? Is that employee going to have a reasonable expectation of rehire? So these are all issues that we really need on a case-by-case basis to be aware of and walk through employers with, because again, it's important to have a consistent and accurate policy to understand, who may be impacted if you have individuals that you're not sponsoring, but that do need re-verification of their I-9 and work authorization. And then again, the business reality versus the immigration reality comes up again here because you typically don't have the capacity to have individuals unauthorized to work because of a government processing challenge. Typically, we used to say a month, 2 months, maybe, but when it's running over 6 months and you need a job performed, again, there are employment and immigration aspects to this that we need to review. Are there any questions? No. So I am actually going to turn it over to Ashley to talk about some of the travel restrictions that we're facing. And this is something that you have to pay attention to, I feel like every hour, right, Ashley?
Yeah, so this is something that has changed many times over the past couple of years, and even over the past couple months. It's been changing and we expect more changes. So, everything we say here, just keep in mind, and we'll remind you again at the end, but you should always be checking the CDC websites, the government websites for the most recent updates to travel restrictions and policies. But essentially the current policy is that most travelers to the US will have to provide proof of full vaccination for COVID-19 prior to entering the US. And when we say prior to entering the US, that really means prior to the moment that your flight departs. So, I know depending on where you're coming from in the world, there can be some pretty long layovers. We certainly do not advise anyone to try to, work within those last few hours. So try not to butt up against that 14 days. So fully vaccinated means that any individual who has received the final dose of the COVID-19 vaccine more than 14 days, again, prior to US travel, prior to getting on that plane. So with the Johnson & Johnson vaccine, obviously that's a single dose. Everyone else, it's 2 weeks after the second dose. US citizens and green card holders are exempt, and there are a couple of other exemptions that I'll talk about in the next slide. But everyone else, anyone who's not a US citizen or a lawful permanent resident or coming to the US to become a lawful permanent resident is covered under the vaccine mandate. And not all vaccines are going to be accepted. And this list, again, has changed a couple of times. They've updated it since. They'll probably update it again. But right now, that is the current list of acceptable vaccines: Pfizer, Moderna, Johnson & Johnson, the AstraZeneca, Covishield, Covaxin, Sinopharm, and Sinovac. So that covers most vaccines, and certainly anyone who is vaccinated in the US is going to be covered. So if we're talking about employees who are vaccinated, who are going abroad, whether it's for vacation or for family or for whatever reason, then they're probably going to be covered. The trouble is that if you do have employees who are not US citizens, not green card holders, and they are going back to their home countries and they want to get a vaccine there, then the conversation just has to be had, making sure that they get the right type of vaccine that will be accepted under this vaccine policy. And mixing the doses is also acceptable as long as both doses come from an approved vaccine. Next slide, please. So as I said, there are some exceptions. They are extremely limited. So those are going to be national interest. And again, these are exemptions from the vaccine mandate. So this is non-US citizens, non-green card holders who are unvaccinated. The exceptions are really national interest, medical contraindications. So if someone cannot get the vaccine because of a medical reason, they can get an exemption. Or discretionary humanitarian waivers, and children are also exempt. So for the medical waiver, that has to be more than a self-declaration. You actually have to get documentation that says that someone cannot get the vaccine for health-related reasons. And these are really case-by-case discretionary bases. There's no set application. There's no set process that people can go through. Consular offices differ, airlines differ. The information that you're going to get depends on who you talk to. So there's no clear path to this, but it is very, very limited. Emergencies are also potential exceptions, but as Nadja said, this does not mean business emergencies. This isn't, an emergency meeting or conference or something like that. That's really medical emergencies, potentially family emergencies, humanitarian emergencies, things of that nature. But this is a pretty strict policy. And an update to this, previously, the vaccine mandate covered air entry and non-essential land border entry. It now covers all entry. So anyone who's entering via land or air is covered under this policy as of January 22nd. So in addition to the vaccine mandate, all travelers to the US, including US citizens, including green card holders, must show proof of a negative COVID-19 test taken within 1 calendar day of flight departure, or proof of recovery from COVID-19 within the past 90 days. So this can be a viral antigen test or a PCR test. But something to just keep in mind here is that if someone is coming from abroad, again, whether it's a US citizen, whether it's a green card holder, whether it's a foreign national, one thing to keep in mind is that it can be difficult in many parts of the world to not only get a timely COVID test, but to get results. And even here, as I'm sure many of you know, it can be a struggle to get your test results in a timely manner. So that's one thing to really keep in mind. The timing of it can be very difficult. This is not a quick and easy thing. You just swab at the airport and get on your plane. And again, depending on where the travel is, this can be more or less difficult. Proof of recovery from COVID-19 within the last 90 days, again, has to be accompanied by a medical professional's note stating that you have recovered and that you are okay to travel. And again, this is something that if someone is going to be relying on the proof of recovery from COVID-19, they are going to want to get in touch with the airline ahead of time to see what type of documentation the airline will accept, because again, this is not just a uniform thing. There's not necessarily a declaration that you can just put a check mark on and it will be accepted everywhere.
One point, Ashley, I just wanted to make is that employers should be mindful if you do have employees or, again, educational institutions with students, you want to be very careful about how you're managing this, because we can provide information like with I-9 compliance, there's instructions and information that we can pass on. But because this is medical related information, because you necessarily cannot be involved with all of the ins and outs of what the individual is doing that's traveling. Again, you want to be careful of what the communications are. I mean, we don't want the employers collecting all of the medical records and so forth.
Yes, this should really be on the traveler, between the traveler and their doctor, and they can reach out to the airline. But yeah, as Nat just said, that's all information that's going to be handled by them and them only. And then if someone is able to get a waiver for some reason, again, it's very, very unlikely, but they may have to self-quarantine and they may have to agree to get the vaccination and then provide proof of the vaccination within 60 days of entry. So this, again, with all of the delays and all of the interruptions, and we'll talk about general travel disruptions at the next slide, but essentially all of these things make it very difficult for US citizens or foreign nationals, whoever it is, whoever your employees are, if they are going abroad, they really need to be in contact with you, and there needs to be a plan for what happens if a positive COVID test comes back or something happens and they cannot get back into the US. And that's something that kind of goes beyond what their immigration status is. So just kind of basic things to keep in mind. Processing delays are continuing for documents on the US side. So passports, TSA pre-check, global entry, real IDs. This is getting better. We are not seeing the chaos that we were seeing early in the pandemic, where there was no information and everything was just kind of stuck in a backlog that had no clear end. It is improving, but we are still seeing delays and we're still seeing discrepancies. So we are seeing, some of these are very quick and being churned out. Some of them seem to get stuck in no man's land, and so it's all still very up in the air. So again, just planning ahead is going to be very important for any type of travel. Again, as Nadja mentioned, expedited services are extremely limited, and business travel is not considered an emergency. And that's going to be true whether someone is trying to get into the US or whether someone is trying to get their own documents so that they can get out of the US. That's not really an emergency. Again, it's going to be medical, humanitarian, and family emergencies are where we're seeing a little bit of movement.
Ashley? So for this part, we're having a lot of executives that travel in particular, even if they have private jets. We used to be able to work with customs at local airports and get people in and out as needed. Not happening anymore. It's very difficult to get people in and out. So it's, again, educating your employees, be it a first line manager or your CEO, depending on the size of your company. Everyone needs to be aware that, we have to work together on getting people in and out. And they're really, the avenues we used to use for VIPs or preferential treatment or any of the contacts, it's just such an exacerbated situation that they're really not working anymore.
Yeah, yep, absolutely. And just the very last thing I want to say on the travel restrictions is that it's not just about coming into the US. You also have to keep an eye on how to get people out. So for foreign employees specifically who may have to leave the US as their status is ending, many countries have entry restrictions of their own. They have vaccine requirements, quarantine requirements, and flights have been really delayed or interrupted. We've seen a lot of cancellations at the last minute, and that can be problematic when you have someone who has to leave the US because they will be out of status. So just a reminder to keep those deadlines in mind and think well in advance. Start planning, 6 months or long, getting them out of the country, having a backup plan and a backup plan to the backup plan, because that can be a really tricky situation if you have someone who actually cannot leave the US, who has been trying and just can't get out. So just things to keep in mind there, and planning ahead and getting in touch with both the employee and anyone else in HR or anyone who has to kind of coordinate that exit plan is going to be very important. And again, just some resources to keep in mind. And in terms of updates, CDC, the US Customs and Border Protection, and the Department of State will all have updated guidance.
All right, so now we're going to talk a little bit on the limitations of remote work and work authorization compliance. As most of you probably know, there was flexibility with COVID-19 policies and I-9 compliance. A lot of employers confused remote I-9 workers with COVID flexibility compliance. Remote workers who have worksite locations that are not necessarily near or close to the employer facility, there is a separate process where, again, everyone has to be I-9'd in person, but you can designate an authority to handle someone in a remote location. COVID flex policies were only allowing telephonic, computerized Zoom verification if there were absolutely no workers physically present at the actual employer work site. There were to be specific policies in place, mandates in place, everyone was supposed to be informed. And it seems like a lot of employers were just taking for granted that they could all of a sudden just I-9 somebody over video chat. So it's really important to look through your I-9 compliance again, and make sure you understand that the flexibility only applies to certain employees. The timelines have changed, and you essentially always need to go back and re-I-9 in person. Even if you had no workers physically present during a time period, if you're back to work or a few limited employees are back into the actual office space, individuals should be coming in to complete the in-person verification. Next slide. With this, I want to just remind everybody, it's a quick timeline. So it's always, the employee completes the I-9 on or before the first day of hire. The employer has their portion to do within 3 days. So if you're going back to work, same thing, it's within 3 days of normal operations to in-person I-9 everyone. We have a few reminders here that there are, because of all of the government backlogs, there are still flexibility provisions related to the documents that may have expired. Driver's licenses and certain employment authorization documents, things of that nature. There are a few receipt notices that are being accepted, but again, looking to I-9 Central and the government websites, Homeland Security guidance is critical here to just stay on top of the changes. For those employers that are E-Verify registered, you have to be careful. There are COVID-19 provisions in how you can register cases if there was a delay, and there's drop-down instructions to follow. But it's really important right now for everybody. As always, we say at the beginning of every year, do an internal self-audit. Right now, because so many policies were changing and there was so much confusion with what COVID flexibility really meant, we are seeing, again, upticks in audits and reviews because I-9 compliance is an area where penalties can be quickly assessed, and they are per employee per error. So very important to take a look at your I-9 compliance. Next slide. One thing we wanted to bring to the attention of everybody is that, be it a foreign national or a US worker, it's really important to know, as I referenced earlier, where your individuals are located. For certain types of visa holders, H-1B workers, if certain employers are sponsoring green card cases through the PERM process, work locations mandate the whole process. Everything that you're doing for the immigration status is location specific. So if someone's home is in a different county, if it's in New Haven County and your office is in Fairfield County, that can be an issue. If somebody is within the normal commuting zone, we have to assess that. What is the government thinking of that standard? Even short-term temporary remote work, if someone is allowed to work from home 1 day a week, if you're going into a hybrid schedule where you're allowing all of your employees to pick, this is going to impact foreign workers, and then it brings up same and similar issues based on how you're treating US workers versus foreign workers. If foreign workers have to actually be at the work site. The other piece that is really important here is, again, uniform policies. You want to align and communicate with the managers and the employees on how you're structuring these policies. And you want to very, very importantly, check with your tax and immigration advisors, because again, we keep finding after the fact that an employee decided to go to the Caribbean for a few months, or the employee decided to go abroad or to their cousin's house in New Jersey, and that's where they've been working. And it causes an impact to a lot more than just that individual. So those are our general reminders. If anybody has any other questions, feel free to reach out to Ashley or me. And Larry, are you going to close out the program today?
Yeah, we can do that. I don't know if there's another slide. I know there is a wrap-up slide. So we actually finished a little bit early. Imagine that. I'm not sure we've ever done that before. So pat ourselves on the back for getting folks out a little bit early.
I have one thing there before you go on.
Hopefully, I'm sorry.
I'm sorry to interrupt you. I did have one follow-up on that Illinois question from earlier.
Oh, sure. Thanks, John.
So the Illinois requirement, they define earnings in Illinois as essentially all earnings. So it's going to be salary, bonus, and commission. So if you have a commission salesperson, the commissions will go toward that 75,000.
All right, great. So with that, we'll close out. I see a question about whether the slides will be available. I should have mentioned that. Yes, they will be. I believe they'll be sent to you directly in a follow-up communication. In addition to this has been recorded, so you can listen to it again and again and again. It'll be sort of a recurring event for you, I'm sure. Again, thank you for joining our program. Hopefully someday soon, maybe the next one will be in person where it can be a little bit more interactive than this platform allows. But we do appreciate all the questions. If you have any further questions on these issues or any others for that matter, please feel free to email any one of us. Email addresses are available on our website, wiggin.com, as well as additional information about the firm, our labor and employment practice, and the individual attorneys. There's a question about recertification credits being available. Someone's going to have to respond to that. Who knows the answer? Someone will follow up with you on that question. So with that, we'll close it out. Thanks again, everyone, for joining us. Appreciate it. Have a good day.